Hello, I'm Sharon, and I'd like to welcome you to our presentation on how to keep your business moving in a data-driven world. We're going to provide you with guidance on some of the core topics and the most frequently asked questions we get from the land and property sector to help you get data protection right. For those of you who are unfamiliar with our work, my colleague Katie will talk a little about the role of the Information Commissioner's Office.
Thanks, Sharon. The ICO is responsible for the regulation of data protection law in the UK. We have specified duties that stem from UK legislation. One of those responsibilities is to provide advice and assistance to businesses. We've developed our SME web hub to help smaller businesses comply with the legislation, and on here you'll find top tips and simple tools designed to help you get to grips with data protection. We also have friendly and knowledgeable staff on our helpline and live chat services who can provide tailored advice to help you get data protection right for your business, customers and tenants. You can contact our helpline, use our live chat facility or send in a written inquiry, and you can see our helpline number and SME Web Hub link at the bottom of this slide.
When putting this presentation together, we have considered the questions we get on the helpline and live chat and the types of complaints we have received about your sector. Based on this information, the areas we will cover today are privacy notices, why you need one and what to include, subject access requests, what is personal data and common questions about providing people with a copy of their data, CCTV, what to consider and how it can be used, and what you should think about before sharing personal data, and finally, some information on how to avoid data breaches. Katie will now get started with some useful information on privacy notices.
So, the law expects you to be open and transparent with the people whose personal data you're using. As such, you'll need to provide them with privacy information in some form. It doesn't matter whether you're a landlord with one property or an estate agent with hundreds of clients. If you're processing personal data, you will need to provide this information. If you're just starting to get to grips with data protection, getting your privacy information in order is going to be a really good place to start. It will help you decide what information you need to collect, whether you need to share it, and how long you need to keep it for. If there's some information you plan to collect, but you couldn't explain why you'd need it, then it's probably not something that you'd need to have. You'll also need to include information about any use of CCTV and any routine data sharing you'll be doing, which are some things we'll go into more detail on later in the webinar. Something else you'll need to put in your privacy information is your lawful basis for using data. Data protection law sets out 6 reasons why you can collect, use and share data about people. These are consent, contract, public task, legal obligation, vital interests and legitimate interests. The purpose and context of your data processing will inform which lawful basis is most appropriate for your circumstances. In practice, you're likely going to be looking at performance of a contract, legitimate interests, or legal obligation. There could be situations in which consent may be appropriate, but it's often not the best lawful basis where you can't offer a genuine choice to someone about how you use their data. For example, if a tenant refuses to give consent for you to input their data onto a property management software, but you do this anyway in order to create their tenancy agreement, then consent isn't going to be an appropriate basis to use. Performance of a contract as your basis would be for situations where you need to process someone's data in order to provide a contractual service to them, like a tenancy agreement, or processing your staff's data in order to pay them. Legal obligation would be for situations in which you're required by law to process data. For example, certain records you need to keep for HMRC purposes, or sharing data with deposit schemes. And legitimate interests would be where you have a genuine interest and need to process data to meet this, and it wouldn't be outweighed by the individual's interests and right to privacy. This is possibly the basis you use when looking at using CCTV or sharing personal data. For more information and help on deciding which lawful basis is most appropriate for you, we have an interactive tool on our website. There's a number of ways you can provide this information, and the most common way of doing so is using a privacy notice. You can either put this on a page on your website, which is easily accessible, or you could have it as a document you provide either as a paper or electronic copy. This should be given to people before you start using their data, such as when a client first approaches you about listing their house for sale. If you don't have a privacy policy in place already, we do have a template on our website to help you. It's important to have a privacy notice, not only because it's a requirement of the law, but because the clearer you are about your use of data, the more trust people will have in your business, and the less likely you'll be to receive complaints from individuals that you've used their information in an unexpected way. Sharon will now discuss subject access requests.
As well as the right to privacy information, people have a right to obtain a copy of the information that you hold about them. This is called a subject access request, or SAR. You could receive a subject access request from anyone, including a tenant, an employee, or a prospective buyer, and the request can be made in any format, including verbally, through social media, by letter, email, or text message. We get lots of questions and complaints about these types of requests, and so we'll talk you through some of the more common topics. The first thing to understand is what is personal data. For something to be personal data, it must identify and relate to a living person. So, for example, being the sender or recipient of an email doesn't automatically make the content of it their personal data. Where emails are sent by estate agents arranging an appointment for a viewing with a prospective buyer, these would not be the employee's personal data. But an email complaining or complimenting them on their work would be. Let's have a look at this in more detail. We see a lot of complaints that confuse property data and personal data. Information about the market value of a particular house may be used for statistical purposes to identify trends in the house values in a geographical area. The house is not selected because you wish to know anything about the occupants, but because it is a 4-bedroom detached house in a medium-sized town. However, as soon as data about a house is either linked to a particular person to provide information about them, e.g. their address, or it's used to make decisions about them. So, for example, the amount of electricity used at a house determines the bill the tenant is required to pay, then the data about the property is also personal data. Let's consider a second example where a tenant makes unauthorised alterations to their house. The data about these alterations is used in relation to the house address, so is data about the property. However, if the data is processed in order to decide whether to take action against the tenant, the data clearly relates to the person who carried out the alterations and, therefore, becomes their personal data. The next thing to know is what data you hold and where it is. Personal data can be held in many different places, so it is important for you to know where it's stored. The obvious place is in your email accounts, but could also be documents on smartphones, personal computers, cloud storage, CCTV footage, and customer relation management systems. If you only use paper records, but these are held in a structured filing system, then these are also caught under the Act. So now we know what personal data is, let's talk about how to comply with the request. When you receive a request from someone, you normally have a calendar month to provide them with the information or to let them know you don't hold any information about them. It may be helpful to note that whilst individuals can ask for copies of their data, this does not necessarily entitle them to complete documents. One of our most frequently asked questions is whether a request can be refused because it's manifestly unfounded or excessive. Refusing a request on these grounds is a high bar to reach, so you will need a strong justification which you should document. If it's clear someone doesn't intend to exercise their right of access, this could be manifestly unfounded. For example, a tenant makes a request but then offers to withdraw it in return for some form of benefit like a reduction in their rent or a fee. It could also be manifestly unfounded if the request is malicious. That is, it is being used to harass your business with no real purpose other than to cause disruption. So that could be if a tenant is making life difficult for you deliberately by emailing you all the time. However, you must consider all the circumstances, as people don't have to give a reason why they want their information. If a person genuinely wants to exercise their rights, it's unlikely that the request is manifestly unfounded. The word manifestly means there must be an obvious or clear quality to it being unfounded, not just that a previous request was, for example. A request is not manifestly excessive just because it may involve a large amount of data. If you've had a tenant or customer for years, it's likely you'll have collected more data about them than someone who has only been a tenant for 6 months. This doesn't mean they're not entitled to a copy of it. You need to consider whether it is clearly or obviously unreasonable. You should look at whether the request is proportionate when balanced with the work involved in dealing with it. This will mean taking into account all the circumstances of the request. For instance, if you refuse to provide the information or even acknowledge if you hold their personal data, will this cause significant damage to the person making the request? Does the request largely repeat or overlap with previous requests made by the same person? And if so, has a reasonable time elapsed since the last one? However, if the later request relates to a completely separate set of information, it is unlikely to be excessive. To help you deal with requests where you hold a large amount of personal data, you could ask the tenant for more information to help you locate the information they want. For example, are they looking for data from a particular time period? Can they give you the dates that will help you to easily search for the information? If they say no, you'll still have to carry out reasonable searches, but you should explain to them that by clarifying their request, you would be able to focus your searches on locating the specific information they want, meaning you may get the information to them more quickly. Having a good retention policy also helps when it comes to handling subject access requests. It helps to make sure that you're only keeping the data you actually need, and it means there's less information to search through. We are often asked if you can charge a fee for handling a request. The quick answer is no. However, you can charge a reasonable administrative fee if the request is manifestly unfounded or excessive, or a request is made for further copies of information following a request. An administrative fee could cover printing, photocopying or postage costs, as well as the admin cost of locating, retrieving and extracting the information. So, for example, retrieving information from archives. Katie will now talk about requests that include other people's data.
Personal data can often contain information that relates to other people. We refer to this as third-party data. In your sector, an example would be when a request is received from a tenant that relates to a complaint made about them, or when information requested by a tenant includes the personal data of the landlord or other tenants. In situations where the requester already knows the information about the third party, if they've previously seen it or they can find it online or in the news, it's likely to be reasonable for you to provide it. It also follows that information relating to a member of staff that the requester has dealt with is more likely to be disclosed than information relating to an otherwise anonymous private individual, like a third-party bidder on a property. There may be times where it's slightly more complicated than that, so there are a few things to consider when looking at disclosing third-party data. Firstly, could you remove the third-party data so it's no longer identifiable? You'll need to bear in mind that just removing someone's name may not be enough if there's other information that could still identify them. If you can't remove the third-party data, you should consider whether you could ask their consent to provide it. You don't have to do this, as there may be situations where you don't have contact details for that third party, or they shouldn't know that a SAR has been made. If seeking consent isn't appropriate, or the third party refuses consent, you'll need to decide whether it be reasonable to disclose it anyway. You should think about the type of information you'd be disclosing and the circumstances in play, whether you owe the third party a duty of confidentiality, and whether you've managed to ask for consent and if the third party has refused this. Sharon will now talk about exemptions that can be applied to subject access requests.
In some circumstances, there are reasons why you can withhold some information from the requester. I'll briefly talk you through some of the ones that are regularly raised by the land and property sector, as these are probably going to be most relevant to the requests you receive. The first one is legal professional privilege. This exemption covers legal advice you receive from your solicitor and information relating to legal proceedings that take place or may take place. This could apply to legal advice you receive when dealing with a difficult tenant or about handling an employment issue relating to a current or ex-member of staff. The second exemption applies to negotiations with the requester. Where information shows your intentions in negotiations, you don't need to provide this as part of a subject access request response. This is only the case where giving this information to the requester will prejudice or affect the negotiations. This could be when negotiating staff redundancies or insurance settlements. You should note that this only applies when the negotiations are ongoing. So if a request is made after negotiations have been completed, you couldn't withhold information under this exemption. The third exemption is confidential references. Where personal data is included in a confidential reference, you won't usually need to provide it. This could apply if character references for prospective tenants are collected, and likewise to staff where references are provided as part of the recruitment process. These are the exemptions you're most likely to consider applying in your sector. If you're wanting guidance on the other available exemptions, take a look at the guide to the UK GDPR on our website. We will now talk about CCTV.
Questions about using CCTV are commonly raised from businesses in your sector. A lot of these focus on using CCTV to protect your properties and tenants, particularly when it can be used in communal areas and who should be able to access it. So there are a number of things to consider when you're looking at using CCTV. The first thing to consider is why you want to use it. You'll need to have a clear idea of what the purpose of it is, why it's necessary, and in what situations you will view and use the footage. Typically, CCTV is going to be used for security reasons, namely to protect your property from antisocial or criminal behaviour, with an aim of preventing and detecting these acts and using the footage to resolve any issues. There may be other issues you pick up on your cameras, but you'll need to make sure your use of footage is fair and that your tenants, residents or staff are informed about what you're going to do with the footage. When we talk about fairness, we mean considering how the CCTV will impact the people you'll be recording. So thinking about when you'll look at your footage is also important. Monitoring it all day to check how many guests a tenant has had over or how many coffees an employee's made that day is not going to be fair and will undermine their right to privacy. The frequency and extent of the monitoring needs to be proportionate. You'll likely be informed fairly quickly if an incident has occurred, so reviewing the footage at that point is going to be reasonable. If you have no reason to view the footage, doing so with the hope you might see something is going to be unfair and intrusive to people. Next, consider where you'll be placing your cameras. Placing cameras in areas which are considered particularly private wouldn't be fair, and the right to privacy of the individual is likely to outweigh your legitimate interest in the footage. You can use cameras in communal areas around blocks of flats as there's less of an expectation of privacy in these areas. However, if these communal areas are inside a property, such as a kitchen or living room in a HMO, really you'd need to have a clear reason for this, such as reports of antisocial behaviour. This is because there's an increased expectation of privacy when people are inside their own homes. Wherever your cameras are, make sure you put up clear signage so people know they're there. Now, if you are dealing with reports of antisocial behaviour, you may be considering whether recording audio as well as video is something you need. Audio recording is much more intrusive into people's private lives, so should only be used in very limited circumstances. If you have exceptional circumstances where audio recording is appropriate, you'll need to make sure you're limiting the amount of audio you're collecting to only what you need, either by being able to turn the function off or only recording audio for a limited period of time. Using audio just because it might be useful say in shared corridors or stairwells, is not going to be justified. Think about how you would feel if your conversations were being recorded, but you couldn't see any reason for this. Next, think about who will be able to access the footage. Every resident of a block of flats probably isn't going to need to have access to the CCTV at all times on their mobile phones, and likewise for everyone in your office. You have an obligation to keep the data you hold secure, so limiting access to footage to only the people who need to see it is going to allow you much more control over what happens with this information and avoid any excess access to data. If your CCTV would be on a shared computer, for example, your family computer in your home, make sure your footage can't be seen by any of your family members if this isn't needed. Finally, make sure you're not holding your footage indefinitely. You'll need to decide how long you'll need to have the CCTV for and when you'll no longer need it. This could be a week, a month, or something similar, depending on your reason for using the CCTV in the first place. As I mentioned earlier, your residents or staff will likely let you know if something has happened quickly, so you're not typically going to need to keep the footage for months. People will need to be informed of the where, whys and hows of your CCTV, so make sure you have clear signage up where your cameras are and that you've listed all of these points in your privacy information, either as part of your privacy notice or you could have a separate specific CCTV policy. So now you have CCTV in place, your next question is probably, well, how can I use this and who can I share it with? Well, first of all, you may receive a subject access request for CCTV footage. Sharon covered SARS in the earlier part of this webinar, so follow that guidance if you do receive one. You may also be asked for footage by the police if they need this for an investigation. The law does allow you to share footage for this reason and without having to inform the suspect. You should still make sure you're only sharing what is actually needed though. If you're not sure why they want the footage or how much footage they need, you can ask them to give you some further details. If you're still not comfortable with sharing the data, you don't have to share any footage unless you receive a court order for this. Sharing footage with insurance companies is also likely to be justified if this is needed to support some sort of claim or there are prospective legal proceedings. Again, you must take care to only provide the relevant footage and should tell people what you're doing unless this would undermine the reason why it needs to be shared. We also receive inquiries regarding using footage in disputes with tenants or employees where cameras have captured evidence of various breaches of contract. If this is a reason you think your footage may need to be used, then you should include this in your privacy information so your tenants or employees know that this could happen. If you want to use the footage for a purpose that you didn't list in your privacy information, you can still do so as long as this is similar to your original purpose and doing so doesn't have an unjustified impact on the people involved. Now, this is not to say, however, that you can go through all footage trying to find something to use against your tenants or staff. As previously discussed, you need to have a reason for looking at the footage, and doing so without one would be excessive, unfair, and open you up to complaints and enforcement action. I'll now hand over to Sharon to talk through data sharing more generally.
Okay, so Katie has discussed sharing CCTV footage, so we will now look at other types of data sharing. Again, this is another area we receive lots of inquiries about. In this section, we will use terms like lawful basis, data controller, and data processor. We talked about lawful basis earlier, so I would just want to explain what we mean when we talk about data controllers and data processors. A data controller is the business or sole trader that decides what data to collect, how to use it, how long to keep it, and makes the decisions that affect the person whose data they are processing. This could be a landlord, letting agent, estate agent, or property management company. We will shorten this term to controller for the rest of the webinar. A data processor has the data because the controller has asked them to do something with it, and they can only use it for the purpose the controller provides it to them for. The law requires there to be a contract between the controller and data processor that includes the responsibilities of both businesses and what happens to the personal data at the end of the contract. A common example of a data processor is where you outsource your payroll processing or HR function to another business. Another example would be where you appoint a debt collection agency to chase up rental arrears on your behalf. Sometimes you may be both a controller and a processor. For example, a letting agent collects data of people looking to rent a property and has data of their employees. For these purposes, they are controllers. Once a rental property is found, the landlord may appoint the letting agent as a data processor to work on their behalf to manage their property and any concerns raised by the tenant. It is for the businesses to decide whether they are processors or controllers and reflect this in the contracts between them. How data is shared between landlords, letting agents and property management companies may differ depending on their roles and what their contracts state. If data is regularly shared between two controllers, you may consider whether a data sharing agreement is needed. Data sharing agreement helps all parties be clear about their roles, sets out the purpose of the data sharing, and covers what happens to the data at each stage. You have to remember that you are responsible for your compliance with the legislation, and a data sharing agreement will help to demonstrate this. So, if as a letting agent you are going to share the details of a prospective tenant's credit checks or references with the landlord, you may wish to consider having a data sharing agreement in place. And this should cover what happens to the data, both if the person becomes a tenant or not. You also need to consider what other businesses you'd share data with. Common types of organisations in the land and property sector may be local authorities, utility companies, the police, debt recovery companies, or tradespeople. It is a common myth that you need individuals' consent to share their data. This is not true. Whenever you share data with another business or organisation, you must have a lawful basis you can rely on, and, like we mentioned earlier, this doesn't always have to be consent. You'll need to choose which lawful basis is most appropriate based on the purpose you're sharing the data for. So, for example, if you share data and it forms part of your agreement with a tenant, then contract may be your lawful basis. But if it doesn't form part of an agreement or contract, you may consider whether it's based on legitimate interests. Katie discussed sharing CCTV footage with the police earlier, and legitimate interest is likely to be the lawful basis you would rely on in this case. The crime and taxation exemption means you don't have to inform people you're sharing the CCTV footage. We give an example of data sharing between a housing association and utility company on our data sharing hub. In the example, a utility company contacted the housing association and asked for the forwarding address of a former tenant who was in arrears on his gas and electricity account. The housing association disclosed the information because they had advised tenants at the start of their tenancy that they would share data in this way because of the contractual relationship between tenants and the utility company. There may be occasions where you have a legal obligation to share personal data of tenants, for example with the local council as part of the licence for an HMO. In this case, if personal data was requested as part of the licensing information, your lawful basis may be legal obligation. Regular sharing of personal data should be included in your privacy notice, as Katie mentioned at the start of this webinar. It's important that people know who you share their data with, and this helps to make sure you are being transparent about how you use people's data. Katie is now going to talk about personal data breaches.
Okay, so now we're going to have a look at the most common breach reports we receive from your sector. We'll then talk through some quick win security measures to help you avoid these types of issues. The most common breaches we see from your sector, both in advice calls to our helpline and in actual reported incidents, are cases that involve data being emailed to the wrong person. This could be due to an incorrect email address, an incorrect attachment being added, or sending out a completed form in the place of a blank one. Phishing attacks are also something we often see, and these are consistently the second most common incident type reported from your sector. These are where you or someone in your business receives an email that looks genuine, with a link to log into an account like Dropbox, and your details are then taken and used by a third party to gain access to your account. Finally, ransomware is the third most frequently reported incident type for your sector, and essentially this is a type of malware that stops you from accessing your computer or the data on it. There's no way to completely protect against malware, but having layers of security can help minimise the impact of these incidents and reduce the risk of data breaches happening generally. So, we'd recommend, where possible, disabling autofill on your email accounts, as this will reduce the risk of the wrong email address being selected. Putting in place a policy of sending a brief test email to any unverified email addresses, such as ones you take over the phone, should also help you avoid any sensitive information being sent to the wrong person. You should ensure that your documents are saved in appropriate folders and are clearly named to show what they contain. This will help to stop any incorrect attachments or completed forms going out in error. Using strong passwords is always going to be good practice, and enabling multi-factor authentication, similar to that used when you log into your bank account, will help to reduce the risk of any unauthorised access to your accounts. Regular training and awareness communications are also a big defence against phishing incidents, and regularly deleting unneeded emails means any attacker who gains access is going to have much less personal data available to them. When the personal data breach team are assessing reports about phishing incidents, we look for measures such as multi-factor authentication and refresher training, so you could get a head start on those now. Lastly, having up-to-date backups of your hard drive and storing these off-site is going to be the most effective way of recovering from a ransomware attack and ensuring that your data is still available to you. Updating your security and antivirus software when prompted will also help guard against these attacks. We also have a checklist in our SME web hub to help you check how well you or your business understand personal data breaches and how to respond to them. Having a clear plan in place if you find out a breach has happened will help you contain the incident and minimise the impact on your customers or tenants. Now, if you do experience a personal data breach, you might need to report this to us. Not all breaches need to be reported, however, so a few things you should consider before reporting are, first of all, does the breach involve personal data? If not, this won't be something to report. An example of this would be where something has only affected business or property data. Look at the potential consequences for individuals as a result of the incident. How serious are these? The impact on a resident from receiving an unwanted email is going to be lower than if they were the target of identity theft. What is the likelihood of these consequences happening? If you've sent some data to the wrong email address, but this was to another estate agent that you've dealt with before, and they've let you know they've received it in error and have deleted it, does it then seem likely they would do something malicious with it? Overall, you need to consider what the potential risk is to the people whose data has been compromised. The more severe those potential consequences are, then the higher the risk will be. Similarly, the more likely the consequences are to happen, the higher the risk will be. If the risk is unlikely, you don't need to report the incident to the ICO. An example of this could be where you've sent an email to people signed up to receive information about new properties on the market, but you've forgotten to put them into the BCC field, so all their email addresses are visible to one another. The email itself doesn't contain any personal data. You think the possible consequences from the email addresses being disclosed don't seem severe, and it's probably pretty unlikely your other customers would misuse them. As such, you think the risk is unlikely, and so this wouldn't be something you'd need to report. You will need to keep an internal log about the incident and the actions you've taken to correct the issue. You should also look at what things you can put in place to stop it happening again, possibly some of the things you saw on the previous slide. If you can't say the risk is unlikely, however, it will be something you'll need to report. If you think the risk to people may be high, say if their financial details have been compromised and they'd be at risk for identity theft, then you must tell them that the breach has happened, what the potential consequences are, and what you're doing to deal with the breach. You should also let them know about anything they can do to protect themselves, such as looking out for fraudulent activity on their accounts. Assessing the risk can often be the most difficult part of an incident, so we have a number of tools available to help you do this. We have our self-assessment for personal data breaches tool, which will walk you through the things to consider and help you decide whether it meets the threshold to report. We also have guides available on our SME web hub for how to respond to a breach and how to assess risk. As always, however, if you're still unsure, you can give us a call on our personal data breach advice line and talk through the incident with one of our colleagues.
The work of the ICO is partially funded through the data protection fee. Most businesses need to pay this unless they meet certain exemptions. For most small businesses, this is £35 or £55 per year if you pay by direct debit, as there is a £5 reduction for using this method. Your businesses will be added to a public register of fee payers, which shows your customers and business contacts that you take your data protection obligations seriously. You can find out if you are legally required to pay the fee by using the self-assessment tool on our website. You can also get further information from our digital assistant on the data protection fee web pages. So that concludes our presentation. We hope you found this webinar useful, and if you do have any further questions at any point, please feel free to get in touch using our live services. Thanks for listening and enjoy the rest of your day.